Ladies and gentlemen, boys and girls, welcome to my new channel entitled Exposing Bar Secrets. What bar am I talking about? Chevy's downtown? No. I'm talking about the Florida bar. Think about it. There are so many institutions that get the focus, the ire, the disbelief of Americans. You know, we all go through periods where we rail against the big corporations or the big banks or the pharmaceutical companies or the lawyers or the House of Representatives, politicians in general. My toilet plunging ability, well, hopefully that one doesn't come to light anytime soon. Nothing like firing oneself up for your first new video on your new channel by unsuccessfully attempting to plunge your toilet. Not exactly psychotherapy. But I'm soldiering on, and I hope you will soldier on and come with me on a very interesting adventure. Because I got an idea from watching what's called First Amendment auditors. You know, those people that go around and film at the courthouse or they film police on the local street corner. And basically, what they're trying to do is shine the light of public attention on these institutions so that we can find out what our tax dollars are actually paying for. How does that sound, you guys? Would you like to come along with me? So if you made it this far, now I'm going to give you a little bit of introduction background. I think it'll make this whole adventure that we are about to go on, auditing the Florida bar, all that more interesting. My name is Kenneth Eric Trent. I'm 51 years of age. I was admitted to the Florida bar on or about December 27, 2003. I went from a GED to a full scholarship to law school. I did good enough on the LSAT to go to Harvard Law, except a friend of mine pointed out that that was only because of affirmative action. Some friend, thank God we don't have him in my life, or affirmative action anymore in the good old USA. But I don't want to get partisan, because this is not partisan. This is about truth and justice and holding our taxpayer-supported bureaucratic institutions responsible. And if you think about it, what government institution is there in the state of Florida that has as much power as the Florida bar, that gets as little attention as the Florida bar gets? You know, everything they do is secretive. Who the hell knows where or how the Florida bar's board of governors is elected or appointed? We have learned a lesson, I believe, from those First Amendment auditors, including a person I support and follow online by the name of Chili DeCastro, who is presently incarcerated for filming police officers in Las Vegas for what I believe is a grossly inordinate sentence. But anyway, looking forward to having him out here in the free world. And while I'm at it, I also need to mention another person I intend to make a difference in freeing from jail, person I wholly believe to be innocent, 99.9% sure, which is as certain as one can get in this uncertain realm we call our earthly existence. Christian Richard Martin, also known as Kit Martin, convicted in the state of Kentucky of a triple murder back in 2020. I watched the trial, have corresponded, and spoke with the gentleman, and I think he's an American hero, is what I think. I think he's a war hero. I think he's incredibly courageous. I think he's gone by the rules all of his life, unlike me. Sometimes I wish I had a little bit more of that character trait. And he's incarcerated for life for a crime he didn't commit. So if you get a chance, in addition to supporting my channel, look online and see what you can do to advance the cause of free Kit Martin, because that's a gentleman that deserves to be free, like many of us. In any event, back to more personally relevant and channel-related subjects. I am now suspended from the Florida bar, probably indefinitely. My petition for reinstatement was denied. And I have to tell you guys, sort of one of my strengths in life has always been, or one of my things that I've used to get past a lot of my own self-made problems, is my ability to admit when I've done something wrong. I am not a guy that lets my pride get in my way of, honestly, if I can see that I've done something, I'm just going to own up to it. We're all human, And Lord knows, it's the denial that so often causes the worst damage to yourself and to those around you. So, I've always been one to fess up, and I just can't fess up on this, guys, because I really didn't do anything wrong. To give you some of the legal niceties, basically I was suspended from the bar. Well, let's take a step back. During my career, I made a big name for myself defending foreclosures. Sort of went by the trade name, did go by the trade name, the Foreclosure Destroyer. Won a lot of cases and got some coverage in the national news as being one of the primary people who exposed the bankers' incredibly disreputable practice of robo-signing during the foreclosure glut that occurred after or during the Great Recession. And so, like any successful attorney, especially one fighting big institutions like Skank of America and Wells Fargo and Shitty Bank and Untrust and VD Bank and Douche Bank and, Fannie Mae not, obviously I probably made some enemies. But in that capacity, like I said, maybe I didn't say, but I've always believed in lawyer ethics. I've always believed in, honestly, having integrity. Always really checked myself, audited myself to make sure that I was acting within the realm of only mildly self-interested decision making, putting my client's interest before my own once they retain me, and trying not to be dishonest or mistreat the other side, trying not to break any of the ethics rules. And so as an idealistic young lawyer back in 2010, it came to my attention that this one law firm was creating fake evidence and using that fake evidence to foreclose on people en masse all over the state of Florida. The law firm, David Stern's law firm, I believe foreclosed on over 100,000 Floridians in that period, maybe 2010 or 2009 to 2013, probably more than that. And invariably, they used fake assignments of mortgage. That is, it was never the original lender who was suing you, so they would have to create a document, and the original lender is always out of business, like Countrywide Home Loans. I call them double-wide home loans. So they would have to create a fake assignment of mortgage and then record it in the official records. They would just make up whatever plaintiff David Stern wanted to say he was representing. Then he would, put that name there. Could be VD Bank, for example, Douche Bank, Bank of New York, Sperminiferous Trust Company Series.com, like Alvida's name. It really was a racket, and I got clued into it, and I'm going to foreclosure court every day, and back in 2010, and seeing these David Stern associates using fake evidence to successfully foreclose on people. So I filed a bar complaint. Back then, I still believed like the Florida bar was a remotely legitimate institution, and I believed that there could actually be justice had and that they would do the right thing and shut this guy down because, man, it was tough on a young lawyer seeing people getting foreclosed on every day with fake documents. So I did what we are required to do, and we know that a lawyer is engaged in a continuing course of conduct that's in violation of the ethics rules. What I did was I filed a bar complaint, and I gave them all the evidence they could ever need to show exactly what kind of fake documents he was using. My high technology division here says I can pull this off the wall, so we'll give it a shot. Brilliant. May need to work up my technology division on just a little bit. But this is just an example. This is one of the documents that I included with my Florida bar complaint. By the way, guys, I'm telling you all this so you'll understand how the Florida bar eventually came after me with a matter of whistleblower retaliation. See, look at this assignment of mortgage. See all those little numbers and lines? That's my handwriting, and I'm pointing out, like, for example, all right, the straw is a pointer. Brilliant. The transparent straw at that. Probably should use that for the toilet. So here we have the signature of the bank officer that's attesting that this loan is being transferred from some defunct bank to whoever's suing you to foreclose. And then this is supposed to be a witness, but she's got the same damn signature. And this is supposed to be a notary. She's got the same damn signature. So I annotated all of this for the Florida bar, and I sent them like a 16-page bar complaint proving beyond any shadow of a doubt that this guy needed to be stopped because he was committing felonies all day, every day at the courthouse. Standard practice. Well, the Florida bar didn't do anything. So I wrote this person. She's going to feature greatly in our story. Adria Quintella. I wrote her a letter back on December 28th, 2011. And this is what it said. Dear Miss Quintella, I feel professionally obligated to write to you. David Stern has committed a massive fraud on the entire Florida court system and thus far has largely gotten away with it. Although the subject of national news articles suggesting he is likely to be criminally tried for these exact same practices, he maintains good standing with the bar. This letter is from December 28, 2011. What is going on here? Several people appear not to be doing their jobs. I am simply floored that the bar has taken no action on TFB file number 2011-50216 or on any other file numbers that may have been associated with my grievance against Stern lodged in September of 2010 and complaining of the wholesale production and filing of fraudulent assignments and false affidavits in thousands of recent foreclosure cases with particular substantiated examples. How does he still have a license? You know me, I would think, as a polite and competent member of the bar, and I certainly respect you and your staff based upon my prior dealings with you. The tone of this letter is compelled by the circumstances, as I hope you can understand. For ease of reference, I include 6 pages of materials submitted in support of the grievance several months ago. I intend to pursue this matter further should I not hear from you with something concrete in the near future. If this matter is not your responsibility, I'm sure you will direct me as to whom I should address this serious concern. Warm holiday wishes, and I do look forward to speaking with you soon. Kenneth Eric Trent, Florida bar number 693601. Well, they eventually got Stern, but they decided the day before his ethics trial that they wouldn't be needing me as a witness, even though up to that point I was supposed to be the second witness that the bar was going to call. And 10 years later, I made a judge angry, as it seems often happens when people actually do their job and advocate for their client and find a loophole and protect them from getting railroaded by the man within the bounds of the law. So this elderly judge filed a bar complaint. Apparently I represented my African-American client a little bit too well in his Alabama-centric 1940-ish courtroom. And he said that my client and I abused the bankruptcy process, and he ordered me to send that order to the Florida bar, basically to file a complaint on myself using his order, which I did. And the idea was that I violated a court order. Well, let me tell you something, guys. What I actually did was, when my client was getting railroaded, I found out, I checked, I thought of something, I had an idea, I spoke it over with her, I looked it up online, I read the case law, including U.S. Supreme Court bankruptcy case law, and I don't know what, a 30-something page law review article, What Was Your First Clue, entitled, The Chapter 13 Debtor's Absolute Right to Dismiss. So after discussing it with Ms. Scott, in order to avoid the effect of this judge's unfair order, which was to go over to state court outside of this judge's jurisdiction and consent to final judgment of foreclosure on her homestead residence, when I knew we could win the case, and that was the only reason she went bankrupt in the first place, was to save her primary residence, get a modification. I had a 32-page law review article nipped and tucked, tied and dried, saying, the Chapter 13 debtor's absolute right to dismiss. So to avoid the operation of that order that my client and I must go over to state court in front of a whole different judge and consent, basically give up a winning hand, fold a winning hand, we just dismissed the bankruptcy case. And so that's not violating a court order last I checked. But that was the genesis of my bar suspension. And when the Florida bar took this thing and ran with it, which I couldn't understand, because I sent the bar the transcript of the next hearing in state court before the foreclosure judge, where I explained the whole situation to him, told him we are not allowed to oppose their request for entry of a final judgment of foreclosure. However, we dismissed the bankruptcy case and we're just waiting until the judge honors the dismissal because, you see, even though there is no hearing permitted according to case law from the Southern District of Florida on a Chapter 13 debtor's notice of voluntary dismissal, it's not a motion, it's a notice. The bankruptcy judge didn't seem to like that very much, and he set a hearing like 3 weeks down the road. So the very effective attorney for the bank drugged my client and I, I needed to be drugged to be in that hearing, but I wasn't. I felt every nuance quite sharply, quite painfully. It was difficult, but I wasn't going to let my client, A, lose her bankruptcy discharge after she made $60,000 in plan payments, and B, lose the right to defend herself in foreclosure court on a winnable case, by a total slouch of a lender who slept on their rights. They violated the statute of limitations. They ignored her calls for years when she was trying to get a loan mod. And, and they sent her a defective precondition mandated, or a mandatory precondition demand notice. So, they had lots of defects in their case. And my client was paying me to save her primary residence. And, I wasn't going to have a partial birth abortion and cause this lady to lose her bankruptcy discharge and lose her primary residence. What kind of attorney would allow that to happen? She was a good, hardworking lady, and I wanted to help her. And she wasn't lying. Never did lie, to the best of my knowledge. So, 10 years passed, and all of a sudden, Adria Quintella is coming after me, balls to the wall, on this violation, allegation that I violated a court order. I didn't violate a court order, and guess what, guys? Every time an attorney violates a court order, that's not an ethical violation. It's an ethical violation for an attorney to, and this is language straight from the rule, it's an ethical violation for an attorney to violate a court order, except where his violation of that order is an open and obvious refusal based on a belief that no valid obligation exists. Well, if I violated a court order, which I didn't, but arguing in the alternative, falls right in there, guys. There wasn't any, deceit or hide the ball or subterfuge or legerdemain or, parabolas. It was just plain old, guys, we need to go ahead and dismiss this bankruptcy case because my client wants the right to defend herself on the merits. That's all she's looking for. It's her constitutional right to defend her interest in court. And you're going to take that away from her. So when we find a perfect, out route, which still would have given up her bankruptcy discharge, he sets an unauthorized hearing and doesn't honor the notice of voluntary dismissal, thereby leading to the time that I have to stand there in front of the state court judge and say, Judge, well, we're not allowed to consent, but I am going to go ahead and tell you that we dismissed the bankruptcy case, and we know based on umpteen Supreme Court decisions, including one, believe it or not, entitled Law versus Siegel, U.S. Supreme Court case, we're entitled. We got our dismissal. So that order doesn't apply anymore, and we would like to defend this case, but we're not able to do that until our dismissal is finalized over in the bankruptcy court, because until then, that judge's order is still in effect. And I had provided that transcript from day one, so I didn't think they could accuse me. I mean, it fit. At worst, it fit within that carve-out or caveat in that rule where it's an open and obvious refusal based on a belief that no valid obligation existed. So, as I'm interrupted with these hard-hitting news-breaking texts, such as, my dog pulled a muscle in his leg. Oh, wait, I guess I gotta let you guys go. Maybe not. Maybe I'll stay here a little bit longer. But fact is that Adria Quintella is coming after me. And so she won. She got her buddy that she went to Northwestern with, appointed as the referee in my bar proceeding, and with a lot of contretemps and basically legerdemain and deceit, we have Florida bar officials running around all over the place committing ethical violations. Well, why don't you come with me while we expose some bar secrets and audit the Florida bar? I'd be honored to have you join me. It's going to be an adventure. So what we're going to do is file 4 bar complaints. All right, guys? And we're going to walk through this process, and we're going to see how they respond when I prove to them that their own officials have committed ethical violations. What's going to happen? Anybody want to lay a bet? Sports betting seems to be partially legal these days. Anyway, no, priest, my Rocco is my bestie. All right, Rocco, say a shout out, prayer for Rocco, peeps. In any event, I sense that I'm beginning to bamble on, so I'm going to let you guys go. Again, the name of my channel is, I don't know, Audit the Bar, exposing bar secrets. We're going to shine the light of public attention on that very secretive, bureaucratic, corrupt institution. Won't you join me? I bet you will. Thanks, guys. We'll speak soon.